All right, here's a quick question for you. Who said this? Quote, felt there wasn't a need in the public sector to have collective bargaining because the government is the people. Because the government is the people. So you can't have unionized government employees sitting down at the negotiating table with a politician because, let's face it, there's a pretty good chance that politician got some money from that union. So you have two people at the negotiating table. You've got the government, right? Then you've got the government union protected employee. Where is the guy who's writing the check? The guy who's writing the check is you and me and everybody else. So we're not even at the table. And there was a case before the Washington Supreme Court from the Citizens Action Defense Fund. And joining us now is Jackson Maynard. You basically said, hey, you know what? We want to be involved. We want to know, the public has a right to know how the negotiation is going and what kind of deal is being cut, because ultimately we're going to be paying the bill for whatever works out between the government and the union and government employee. So Jackson Maynard, the Washington Supreme Court says, you don't really need to know, right?
They did, unfortunately. And, that ran contrary to the case law in which the ACLU had sued the city of Seattle over police negotiations to try to get those records from those negotiations. And the court in that case had said, once the agreements are signed, then the negotiation is over. And a special exemption that is called the deliberative process exemption that deals with negotiations and wants to protect the government and create a sphere in which they can engage in some protected negotiations with the union. But once you have a signed agreement, that negotiation is over, and the public has the right to get the documents that were used in those negotiations. And that's what we wanted. We wanted the initial offers to see how hard the governor's office had fought with the public sector unions in these negotiations that, by the way, culminated in $1 billion. It was a record back in 2022 when these were negotiated, $1 billion in salary increases and benefit increases for the unions.
So the Washington Policy Center has always been calling for more transparency. We just want a seat at the table because we're going to pay the bill. We just want to know how it's going. So when it came to you guys over there at a Citizens Action Defense Fund, someone was finished, give us the transcripts, basically. So did the government say we can offer you 2%? The union came back, so we won 3%. And when we don't know, and the Washington Supreme Court, I think under legislative privilege theory, is that what they came up with, that we don't have a right to know?
It wasn't. It was not legislative privilege. It was called the deliberative process exemption. And basically, if there are drafts or there are negotiations, the case law interpreting this privilege said, look, we don't want to necessarily get the documents while the negotiations are going on, because that could disadvantage the government in these negotiations in both parties. So, but once it's over, once it's done, the public records law says that those exemptions have to be construed as narrowly as possible. And so we won at the trial court. We actually got a penalty against the Office of Financial Management in the governor's office, who took the position, not only did we have to wait after they had signed agreements with the unions until after the legislature funded the agreements in the budget, but then we had to wait longer until the governor signed the budget into law. So 9 months. So basically, you get the information after it does absolutely no good, and you can't use it to hold your government officials accountable. And that's just not consistent with the Public Records Act and its goals of transparency and accountability for government officials.
It was Franklin Delano Roosevelt that really just couldn't believe that he found it to shock the conscience of the court that you would have a government employee join a union, and then have that union, quote unquote, negotiate with a politician who basically got paid by the union to win and run and then write laws. I mean, it just stinks to high heaven. The whole thing does, right? Whether it's a Republican or a Democrat, it doesn't matter. Because as I said in the beginning, Jackson, that we're not at the table. We're not at the table till all of a sudden the bill comes out and what have we agreed to? There's nobody to hold either party at that table accountable because ultimately, as you say, what was the total amount that Inslee had approved? How much?
It was $1 billion in increases just for the unions. And to your point, the Seattle Times editorial that came out, and the Seattle Times is not a progressive newspaper, and yet even they were incredibly critical of the court's decision because they put it in context of the $9 billion increases in taxes that the legislature just passed when they were funding the latest round of agreements. And yet they were still cutting childcare. They were still cutting, college benefits for at-risk youth. The idea that we would not be allowed a window into these negotiations so that we could make sure that money is being spent wisely, that the government was pushing as hard as it could to get the best deal for the taxpayers while they're raising taxes and cutting other things is just ridiculous. And it's not consistent with the other level of transparency we have in the legislative budgetary process.
But Mr. Maynard, even if we had a view through the window, there's really not much we can do. The window is a bulletproof piece of glass that does not hear our voice. So we would just be standing there pounding on the window, but nobody would hear us because the deal is already set and done and the ink will dry on it. And then we can rant and rave as much as we want. But we're not actually in there doing anything about it. The only dissent, which I was really happy to see. So this is from the one dissenter from the Washington Supreme Court. The people have the right to know what their government is doing. That value is the basis for the Public Records Act. The presumption is that the public is entitled to information their government holds. Withholding information is the exception, and this court's responsibility is to construe an exception under the PRA as narrowly and as reasonably, as you said, as possible, so the information is disclosed and not withheld.
Yeah, I'm so glad to see that dissent. And that was essentially our argument for the court. And at least it was articulated, at least it was put on the table. I'm going to respectfully disagree with you a little bit, John. The idea that having this information could have no impact. Timely access to information is a big part of the Public Records Act. And the legislature has the power under the Collective Bargaining Act to reject the agreements. Well, if people don't have the information from the negotiations,
yes,
they can't go to the legislature and testify in committee and say, this is not the best deal. Here's where they started. This is where they ended. You, legislature, should reject these agreements, or you, governor, should veto them. So it is not a done deal. But that's the problem with the court's decision, is it acts like it is a done deal and treats it that way, and treats the legislature and governor as part of a separate, as being in the room in the negotiations, and they're just not. They're separate agencies. The legislature is a separate agency and not part of these negotiations. And for the Public Records Act, they shouldn't be treated as such.
So without putting you in an awkward position there at Maynard Law, will you ever have to testify before the Washington Supreme Court?
Oh, no, I certainly argue in front of them. And, I have an obligation and a duty of respect for the tribunal, and I just respectfully disagree with the court. And I think they were just wrong. I think they were wrong on the law. I think they were wrong on the policy here. And I was glad to see that position reinforced by the Seattle Times.
So I'm going to say this without you saying it. These are my words, not yours. You don't have to nod. You can turn your head away for a moment. It would seem to me that because in the state of Washington, we elect now our Washington Supreme Court, we elect the Supreme Court members, and it is apparently nonpartisan. But let's face it, money is the mother's milk, right? And I think a lot of milk is squirted on some of these people, and they tend to go the same way as the Democrats go. So if they have something that keeps the boat afloat for them, they tend to rule in that favor. And it's a very progressive court, but that's what you get in the state of Washington, where we have complete control by the Democrats in all branches of the government. And unfortunately, I think for people that feel like, where's my voice being heard? I don't think it's necessarily heard there at the Washington Supreme Court. So I wasn't shocked by the ruling. Were you?
Just if you go back and you watch the argument, it felt like a lot of the justices, and many of whom are very knowledgeable about the Public Records Act and its importance and the limitations of these exemptions that the agencies apply, and have actually issued opinions enforcing those limitations. I guess I would say I was disappointed. The public sector unions filed an amicus brief in support of the state's position. And I was just disappointed that the court went along with that position. I think the stronger argument was the one in the dissent, and the one that's most consistent with accountability and transparency. And so, I did like that the Seattle Times challenged Governor Ferguson as well, and created an argument. Look, you say you want to be transparent. You don't have to follow this bad decision. You can actually do the right thing and enforce a policy in which you're going to provide these documents consistent with the Public Records Act and good law and good policy and transparency.
Well, there's a little daylight, so we could have Ferguson say, yeah, I'm going to make sure that this thing is open to the public so they're aware of it, and then they can call their lawmakers and say whether they're happy or unhappy with it, and then I'll hear from the people. That would be wonderful. So that might give us some hope.
I think it could. Obviously, Governor Ferguson would have to, he would have to disregard the.
Be nice, Jackson. Jackson, be nice.
He would have to disregard the political pressure that could come into play, but hopefully he will take seriously the Seattle Times editorial and take a hard look. He's a lawyer, and he said he wants to be more transparent. So this is an opportunity for him to put his money where his mouth is, and do the right thing. Okay.
Well, listen, we'll leave a little hope of a little glimmer of hope there. Jackson Maynard, thanks so much from the Citizens Action Defense Fund. You tried your best, my friend.
We're going to keep fighting, though, John. It's not over.
What's the next one you have? Do you have anything else you're firing at these guys?
Yeah, we've got a few different things during the pipeline. I would say, without betraying attorney-client privilege, there was a lot of bad law and policy that came out of the legislature this past session, and we're certainly looking very, very hard at a lot of those bad laws and bad policies. And I think you're going to be hearing a lot more from us in the next couple months on that. So bad laws make for more work for you. It does, but, it's a privilege and an honor to keep up the fight for freedom. Thank you. All right, Jackson, appreciate your time. Much appreciated. Thanks for coming on.